start this shindig. All right, we've got enough people of our board members here to take care of things. Terry Stamper couldn't be here because of a death in the family. Everybody else is here. We need a pledge of allegiance and a prayer. Who wants to volunteer? Okay.
All right, pray with me. Heavenly Father, Lord, we thank you for this time that we can have to come together and to do the community's business. Father, we ask you that all of our hearts and our minds will be open to your will, that we can do the people's business here in a way that's pleasing to you, Father. We thank you for your love, your grace, and your mercy. In Christ's name we pray. Amen.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Okay. New business, 2.1. Discuss and take appropriate action to adopt resolution language amendment to the special code, district code 1042 Hood County Hospital District.
Yeah.
Any discussion?
Yep, we have already passed this, but it was a 7-2. I went down and had to sit down with Judge Lawson on that, and both her and Birdwell have indicated that they need these to be unanimous resolutions before they will, take them up. Once it is a unanimous resolution from us, nobody else cares. It's specific to Hood County, so it's not like anybody's gonna fight against it. So if we can get our legislators on board with it, then it's pretty much a slam dunk from there. So all that this resolution is asking for is dissolution language. It doesn't specify a trigger for the dissolution, but it gives us an out if something happens, if we don't get a lease, if we don't have any way, if we run out of money, then it allows the hospital district to have the ability to just board up, send the stuff over to the county, and let the county take care of it. So that's all it is.
So, question, so since the legislature created this, even though you say we're gonna board up, if it come to that, we're dissolving, does it still gotta go back to the legislature to be totally dissolved?
No, not with the dissolution language.
Okay.
With this amendment and what I foresee in that, it leaves the decision to the board of the hospital district, and if they decide to dissolve it, then it automatically puts into place the mechanism to do that and what happens with the assets and everything.
If I could add, just to get it on the record, the Texas Constitution, Article 9, Section 9 is entitled Creation, Operation, and Dissolution of Hospital Districts. And it says, within that statute, in the first few paragraphs, or the Constitution actually, says the legislature may also provide for the dissolution of hospital districts, provided that a process is afforded by statute, and it lays some stuff out. So, what we're doing is just asking, well, they didn't do it with this special legislation. And I will point out that in our special legislation for this district, Special District Local Laws Code 1042, I'll note that 1042.004 says that the district support and maintenance is not a state obligation. So the state is going, whatever happens, we're not putting any money in it. And so I think that's important because it says, the support and maintenance of the district's hospital system and any indebtedness incurred by the district under this chapter may not become a charge against or obligation of this state. So where is it gonna go? And I talked about this last time. It's gonna end up back on the county. The bottom line is this, so this is just enabling. If the hospital district stays solvent, then it doesn't need to trigger this, but you know, this is unusual to me to see something that has no way out within itself. So that's my Safety Code 61002, 610.022, it states that, county obligation, this is to bolster my prior comment. A county shall provide health care assistance as prescribed by this subchapter to each of its eligible county residents. Well, who's the county? Well, that's the county that's the county. The, B, that's part A, subpart B, the county is the payor of last resort and shall provide assistance only if other adequate public or private sources of payment are not available. So right there is where it falls back on, and I think this resolution is just to ask the legislature to come up with whatever language it needs to cover that. And it's not saying dissolve this, it's not asking for that, it's just saying, can we put this language in there? And like Commissioner Andrews said, it's probably a consent agenda item, that if we pass this unanimously, and of course that happens all the time in Austin, right? They always pass everything unanimously down there, but they're requiring us to do it, so I hope that, anyway, that's my comment.
Thank you for your comment. Anybody else have any comments or questions?
That'll make a motion that we adopt this resolution.
Second.
Okay. Any questions? There being none, all in favor say aye.
Aye.
Any opposed, say no. Okay,
Having
congratulations.
one absent, does that hurt this?
Sir?
No, I don't think so. Still, I think you voted for it last time.
Then it's getting to be like the Wizard of Oz, well, you need to bring back something else now, you know? We've got a quorum here, so it's unanimous, so.
Okay,
And
2
Terry voted for it last time.
Yeah, he did, that's true. Thank you.
2.2, discuss and take appropriate action to adopt resolution to request the Texas Legislature resolve common law doctrine of incompatibility created in Special District Code 1042, Hood County Hospital District.
Yep, and this one, we passed this one, not unanimously earlier, and this one's just saying, hey, is there a way to get commissioners off of here? That's all this resolution is. So.
Get out!
If by code I could do that, we'd do it. So, it's just asking to amend that legislation to say that this, again, I feel that there's a conflict with common law doctrine of incompatibility with this, with the Commissioner's Court sitting on another board of a taxing entity, both being able to tax. So this is just asking the legislature to remove the Commissioner's Court from this deal, however they see fit.
And I have to agree with that, and I've heard comments that, well, the legislature wouldn't have done this if it was something wrong with it, but that was quite a few years ago. And I will point out that in our own enabling legislation, 1042-251, it says imposition of ad valorem tax. It's subsection A says the board shall impose a tax on all property, and they decided not to. They decided not to against the statute back then. So I'm kind of, I think this is a little bit more of an open question on that issue. But all the AG opinions I've read that look to this issue of the doctrine of incompatibility with us being on two taxing entities state that this is not correct for us to be on here.
To your point, Dave, I read that this was established in 71 by the Texas legislature. And to Danette's point that she made at the meeting that we had last week, that I think we're the only one that has the county commissioners and then the four, that are nominated by the county judge. The question, did anybody ask the legislature when you were down there why they did that? Because they knew that there's 144 districts that are established in the state of Texas right now that I'm aware of. And some of them are combined districts because of the size of some of the counties. And yet if they appointed these other districts and they were doing it under an elected position without the county commissioners or the judge, why did they, how did we get singled out, I guess was the question. And it's been something in the back of my mind that I've not quite understood for a period of time. And quite frankly, that's why, in the last meeting, I voted against it because, I didn't really understand how they selected that and why it has become such an issue. I understand the double aspect of what county commissioners can do on tax, but for us to levy a tax, we had to have it approved, through the vote. One of the questions I asked, I think, a couple of meetings ago was the question is related to, can the county commissioners impose a tax without requiring a vote from the citizens?
At current, no, but if at any point in time, that vote comes through, then this is a taxing entity that sets the tax rate automatically. It only has to be voted on once, then you're constrained with Senate Bill 2 with the 8% increase. But at that point, this board is deciding what the tax rate is, so that it does put us back into that situation. Just the one special time that we would have the voter approve tax rate increase would only be a one-time event.
So this entity is subject to the same, well, except for it's 3.5% versus 8%,
Right.
right? But the same logic that, the commissioners are, is that if you stay within a certain amount, for the county, it's 3.5% of revenue, then you don't have to go ask the voters for what's called a battery, a voter approved tax rate election. The same thing would apply to a hospital district, whether it's this one, the way it currently is, or a different one that's formed a different way, it would still have that same restriction.
Well, my understanding was that because we lost the vote on the 2%, or the 2 cents that we were requesting. That basically, if it went to where it took the county commissioners out, or it placed the onus totally on the county commissioners, you still have the right to, you could, if the hospital district needed the money, you could still entertain the 3.5% tax increase. Am I missing something here?
So, what you're saying is, in the future, if it were to come about that this responsibility was on the commissioner's court,
Yes.
and that section of the budget needed more funds.
Yes.
We would have to work it within our budget to be under 3.5%, or go and ask the taxpayers to vote for a higher tax rate.
So you would have to ask for the vote.
But 3.5% of what they get already would cover the hospital districts yearly and more.
And,
It would have to be 3.5%.
and if I may offer an anecdotal, explanation for what happened in 1971, this is my understanding, is the county judge.
You weren't here then?
I'm sorry?
You weren't here then?
I was not here, and that's, okay, I was alive though.
Well, you were very young.
Barely, yes. But the county judge was, my understanding, pretty good friends with was it Doc Briscoe? And, since this was only related to this county, and as I stated before, this is gonna be, whatever we do today, if we do it unanimously to send it back to our, state senator and our state legislator, so they can carry it forward, it's gonna be equivalent to a consent agenda item. Nobody's gonna fight them over it. And that's what happened in 1971. Now, I would say that perhaps there is something out there called legislative history. You're not gonna ask anybody down there what happened. I can tell you, they're gonna go, I don't know. But there may be a way to look at legislative history to see if there's anything relevant to this creation, but my bet is no, because it was a deal done between these people and they just did their deal.
And the AG opinions against this have all been more recent than that. It was, two by Ken Faxon and one by Greg Abbott, of a particular note there. And all of them have been significantly after that legislation passed.
And one other thing, the legislature may go, they may look at it and go, I don't see a problem with it. That could happen. If it does, maybe they'll go look and find out. But on its face, to me, there's that doctrine of incompatibility, since we're both taxing entities.
When this began, back in 71, the judge and 4 commissioners wanted to be in control, so they had 4, not civilians, 1 physician. I only got here 3 years after that. But the commissioners court controlled the hospital district, and that's the way they wanted it. And that's the way they did it all the way to when they rented it out, leased it to the hospital, the community health systems. And the people that, of the commissioners court, that were running for election that year, part of their vote for me was, you won't have to pay any tax on the hospital district anymore.
See, and you can see right there why this is a conflict.
Uh-huh.
That's a very good
Yeah.
example.
And that was in direct contravention of the statute itself.
Yeah, well, you can't trust all commissioners.
Just-
Amen, sister.
Well, the problem is you have the media and all the computers and all the things to search, and some people didn't know.
Mhm.
True.
They went with whatever they were told.
Mhm.
Well, do you wanna pass this, or you wanna, okay. Get a motion to,
So moved.
you're in moving to,
I'm in a moving kind of mood, so.
I'll second.
okay.
She's in a seconding kind of mood,
Okay, any questions or comments?
So are y'all just purely voting to remove the commissioners from the court, from this district?
No. It's,
Why not?
I think that the end game is yes, because of the compatibility issue.
I understand that.
Yeah,
Just didn't know
so,
what you're actually voting for.
well, it's,
yeah.
do you wanna read the bottom?
yep, we'll do that.
You're gonna read it, I'm not.
Okay. I think I can do this without my glasses on this screen. Alright, it says, whereas the Hood County Hospital District, the district, was created under the authority of Section 9, Article 9 of the Texas Constitution, and whereas the provisions, administration, powers, and duties, general financial provisions, and responsibilities as set out in special district local laws, Code Chapter 1042, Hood County Hospital District of Hood County, Texas, and whereas the district was created to provide all necessary hospital and medical care for the district's needy inhabitants, and whereas pursuant to 1042.003, the boundaries of the district are coextensive with the boundaries of Hood County, and whereas pursuant to 1042.051, the members of the Hood County Hospital District Board includes all members of the Commissioners Court of Hood County. And whereas both entities have authority to levy ad valorem tax in overlapping districts, thus, based on multiple AG opinions, creates incompatibility and violates the common law doctrine of incompatibility. And then it cites Attorney General opinions KP 0023, KP 0119, and Greg Abbott 032. Now therefore be it resolved that the Hood County Hospital District requests that the Texas Legislature resolve this violation of the common law doctrine of incompatibility by amending the enabling legislation, Special District Local Laws Code Chapter 1042, Hood County Hospital District of Hood County, Texas, to provide for a board of directors in a manner that remedies this incompatibility and revise any other necessary sections in conjunction with this change. So, that's, all it specifically is asking for is to remove the incompatibility of the commissioners on this.
So, question, you look at the urgent things that this board needs to do. Okay, if you break it down into three areas, either, the ultimate sale or lease of this hospital, secondly, the taxing issue, then thirdly, this other arrangement you talk about. Will this slow down those other two processes, in anyone's opinion?
No, if we pass this unanimously, the legislators take it, and like you said, they put it on a consent deal and it just.
So it passes and it goes to them, then what?
How quickly does it,
Then
do
what?
we kick y'all out?
It's, I couldn't imagine that they would do anything before September first would be my
Okay.
guess, cause that's
Or January
typically
one,
when
'cause there's
things.
some stuff that
Yeah.
Virgil is working on right now. One of, there's two of them, particularly, one of them goes into effect September one if it passes. The other one goes in January one, for 26 if it passes, so.
And that would make more sense, it would give us the entire
I
year.
don't see this as an immediate action, I see this as either the September one or January one effective.
Well, they gotta determine what they're going to do, which has not been determined, and based on that determination, if it means an election, then they gotta go their process, so it may actually extend past that.
Don't know.
Yeah, you don't know, you don't know, and you got till March the 12th to get the last bill in.
Yeah, and the only urgency at all in this is that they're in legislative session right now, and they have to have all their bills filed by March 14th. So that's the only urgency with this at all, is if this is gonna happen in this legislative session, it has to happen.
We'll have to waste 2 more years.
Well,
Yeah.
there's one other way to get rid of any board members in this board. If the commissioners don't wanna be on the board, they just don't show up for 3 consecutive meetings, because in our rules, if I don't show up on 3 consecutive meetings, I get kicked out.
But with us being legislatively appointed to this board, I don't know if we
can't kick
can
you
get
out.
kicked out.
You're not
Try as
special,
we
yeah.
may.
I can kick you out.
I don't think it's that easy.
Yeah.
I mean,
Or
there
you
are-
Kick him out? Maybe not you, but you kick him out, yeah.
I think we're stuck until the
Yeah,
legislature
no, I-
gives us a remedy.
I agree with that, I mean, with what, we're stuck here until they do something one way or the other.
So is the
And we have
answer,
to give them.
it doesn't slow down the process of the other two issues?
No, not at all.
And we have to give them permission to Dave's point, to make that decision, right?
Well, they're looking for us locally to say, this is the way that we need to go forward with this. And if we do that unanimously, they're totally on board and they're
And they'll draft their own language. You know, they're gonna draft their own language. If that happens.
We can't get rid of the commissioners and keep the judge.
I don't know, they're gonna.
You probably
who
talk to
knows?
somebody.
They may keep somebody, there may be, who knows? She looked at all the other different,
Yeah, I didn't see when that.
My problem is if the judge, whether it's you or the next judge or any of y'all become a judge, you pick the other board members. Otherwise, if they have to be elected, people who want to sit on this board have to pay for election. They have to advertise, and they have to pay for that. So, you've got money involved. What's to keep somebody from trying to get money from the hospital district out from under the table?
I think
That's
that's
my only
illegal,
problem.
I mean, somebody go to jail for that. And
Yeah,
as
but
far as elections.
how many haven't? Yeah.
Can't speak to that, but as far as elections go, I don't
Put your hand under
imagine
the
that it
table,
would be
yeah.
it'd be a huge cost, and people that want you on the board will give you a little money to go buy yard signs too. So, I don't think the cost of elections is a significant deterrent.
cause you've paid for one, and I've been on this board, and I haven't been paid jack.
Especially if it's in conjunction with a normal May or November election, where cost is.
Right now, all you're asking for is them to clarify incompatibility. That's all you're asking for. They could very well change a rule of some sort in that legislation, keep you on. I mean, that's all you're asking for.
Right, yeah, just to
It
resolve.
could go either way, they can say, we're good with, commissioners and the judge being on the board, or not, I mean, that's all we're asking to be done.
Yeah, I think that was
Okay.
the reason for the questions I was asking Dave, because one of the things that concerned me is we're talking about a leasing arrangement, which Dr. Barnes has referenced, plus either the sale of the entirety of the property to the hospital stuff, but we're still required as a county, we're still responsible for indigent care. And the question in my mind was that, okay, if it comes down that county commissioners and the county judge are not on the board, and there's 4 that are serving on the board at the, request of the county judge, how quick can we put something together to get the necessary board such that we're taking care of county business as required by state law? And that was good. I think there's some kind of a time vacuum in there that had me concerned as it related to how this would all maturate to.
Since we're supposed to have 5 members as a quorum, otherwise we can't do anything.
Well, I'm just saying that we're obligated to take care of the indigents.
Yes.
We were asked by the county to take care of the jail inmates. The deal is that the proposition was that we're trying to negotiate either an extended lease or a sale of property. If that happens, and we have that money, and with what we're doing, and I'm asking from the standpoint of efficiency to take care of the indigents, not that I'm trying to be anything stopgap in this. I had a concern that there might be a time lapse in there between whatever we negotiate, whatever the legislation decides, and whether or not we still have a board to do the county business to take care of the indigents. That's my concern.
And I think like Jack said, the soonest it would be September, and probably not till January or maybe later.
Normally legislation is either September 1st or January 1st.
So there would be plenty of time for transition and for the current business that's being considered to be resolved.
Well, I don't know that it would be an extended period of time if you were to have an election. I mean, that's kind of, it takes a bit to put that together and stuff.
But it would leave the status quo until
Yeah.
the transition happens.
Right,
So there would be,
right.
It would have to leave the
Now,
status
they gotta
quo.
put something in there to
That's somebody.
address, when, if there's gonna be an election, they have to address that when it's gonna happen.
Right, and it wouldn't just, the board would stay intact until a new board was in place.
And elected positions generally take office January 1, so.
And you wanted to say something?
All I wanted to say is, if we've identified that there's potentially an issue with the, compatibility or incompatibility, wouldn't that affect any decision made from this point forward? Meaning, if you choose not to move forward with, finding the difference in the language, then you still have an issue with incompatibility. And so if you're trying to hurry up and make a decision before the state legislators or representatives give us some sort of, remedy, then, is there still an ethical issue there? That's my concern.
No, that's only on tax issues. Double taxation,
Right.
not
Not
come back
necessarily,
in
the
our
structure
business.
as a board is a concern, because you have your vote and you have 4 people that you've appointed. And so specifically when you're talking about extending this, a lease or a sale, these are big decisions that elected people want, or people wanna be able to have, some sort of say in it. And I think that's the concern, is you have to, you really have to look at the incompatibilities before any decisions are made at this point forward.
And, you brought up the issue about the inmates. with the hospital district paying for the inmates. That is a situation that's directly applicable to that, because 5 of the members of this board said, hey, it's a whole lot easier for us to just have those paid out of the hospital district than out of commissioner's court, let's put it over in the hospital district. And that controls
The hospital
in
district
the
gets,
lack of a separation there.
Yeah.
That's what I'm saying, the hospital district kinda gets the short end of the stick on
the
that.
hospital
Let's just
district gets to
call it
pay for
what it
all
is.
of the health care for jail inmates, whether they're indigent or not.
Yeah, but
Because
your
it was-
next, if hypothetically, if you get removed and you have an election, you get the public to do that, they can come back to the first meeting and go, you know what? Constitution says the government of the county is responsible, and we'll put that back on the county.
Except
And
if
so
they're
that,
indigent.
all that you're having problem with now can still be dumped back on the county.
Yeah.
By the first meeting of that new board. Because the Constitution says the county's responsible. Not the enabling legislation of the hospital district. That was just a good award deal they did back in, whenever they did it.
When was the transfer from the, inmates being cared via the, hospital? When did that happen?
Pardon me?
When did the hospital district assume the,
Well, they didn't assume it, they got it dumped on them, but yeah, it was in 96.
As part of the lease agreement, is that what
Yeah.
happened?
Call the
They-
question, let's go.
No, go ahead.
I said, let's call the question. Let's
We got a
vote.
motion and a second, so.
That's right.
Yeah, but we had to have discussion.
Okay.
And there being no more discussion or questions, all in favor of whatever you said,
That resolution.
resolution.
There you go.
Say aye.
Aye.
Any opposed?
It's a good thing.
It passes, congratulations. Okay, that's all there is for this meeting. The next meeting will be the real meeting. It's the March the 28th,
I think so.
and it's right here at noon.
March 28th.
Yes, 2025.